Hello and welcome. I'm Afra Sharipur. I'm Senior Associate Dean for Academic Affairs at UC Davis School of Law. And thank you all for being here. Today's talk by UC Davis Law Professor Leticia Saucedo kicks off the third academic year of our ongoing Racial Justice Speaker Series. Created in fall 2020 in response to the tragic killings of George Floyd, Breonna Taylor, and others, the series began as an examination of the alarming racial inequities within the U.S. criminal justice system. It quickly grew into an exploration of the effects of systemic racism, both overt and quietly insidious, on all areas of the law. This series has featured some of the finest legal scholars and practitioners of our time. And today's speaker happens to be one. An esteemed member of the King Hall faculty for more than a decade, Professor Saucedo also serves as National Senior Counsel for the Mexican American Legal Defense and Educational Fund, one of the nation's most prominent civil rights organizations. Last year, Professor Saucedo rejoined MALDEF, which he previously worked as a staff attorney in San Antonio from 1999 to 2003. A Martin Luther King Jr. Professor of Law at UC Davis, Professor Saucedo is an expert in employment, labor, and immigration law. She teaches immigration law, employment law, labor law, and for our lucky one else, torts, which she'll be teaching next semester. She's been a visiting professor at Duke University School of Law and a research scholar with the Chief Justice or Warren Institute on Race, Ethnicity, and Diversity at UC Berkeley. Professor Saucedo's research lies at the intersection of employment, labor, and immigration law, focusing on the impact of employment and labor laws on conditions in low-wage workplaces and on the responses of immigrant workers to their conditions. Her law review articles have appeared in the Washington University, Notre Dame, North Carolina, UC Davis Law Reviews, among a whole host of other leading publications. Professor Saucedo is a member of the American Law Institute and co-editor of the new University of California Press book series entitled Race, Labor, Migration, and the Law. She's a graduate of Harvard Law School. In her talk today, Banking Access as a Civil Right, Professor Saucedo will address how migrant integration requires full participation of immigrants at all levels, including access to financial services. She will discuss the legal strategies and theories used in litigation against banks and credit unions that fail to provide full access to immigrants, and how MALDEF has sued financial institutions on immigrants' behalf. Please help me welcome Professor Leticia Saucedo.
Hi, thanks for that wonderful introduction. Great to be back at Davis for a little while, at least until next semester. I recognize some faces without the mask. Thanks to you all. I want to start. This is a little bit of false advertising because I was told to talk about my work at MALDEF and how I got to MALDEF and that sort of thing. So I'm going to start there before I start talking about banking access. And full disclosure, banking access is a little bit outside of my employment labor law field. So I'm learning right along alongside the lawyers who are actually doing these cases. But a little bit about me, I started as a civil rights litigator in practice right after law school. And I was doing employment discrimination cases, immigrant rights cases, and education cases at MALDEF. I quickly learned that I hated discovery, which is a huge part of litigation, and I hated court imposed deadlines. There was just this external pressure, and I just couldn't deal with. I can set my own deadlines, but I don't want to take this thing. So I entered academia because I loved theorizing outside of the brief, and I spent a lot of time in that thinking about theories for our cases, where they might have flaws, what the future implications of our arguments might be. And I figured that in academia, I could be able to do that. And I hoped to inspire people to do the kind of work that I ultimately ended up doing in litigation. But I also felt like I needed to keep it practical. So even those of you who are at the class, even as I teach, I try to keep things practical as possible. So a couple of years ago, I was offered the opportunity to engage in basically the best of both worlds, right? That is becoming the National Senior Council for Malta, which meant that I would be supervising and overseeing the work of people who were starting out in careers or in the mid-level of their careers, and really helping them think through with their eyes the arguments that they were making in their cases and think about their arguments. So I'm deeply honored to be doing this work, and I'm grateful to UC Davis for letting me do it at the same time I'm teaching courses. All right, so MALDEF is the Mexican American Legal Defense and Educational Fund. It's a civil rights organization that has been around since the 1960s. Its goal is to ensure that Latinos are adequately integrated in our society. It works in several different areas of law: voting rights, education, public accommodations, employment, and immigrants' rights. So from an equal, and most of the work that it does is from an equal protection lens. That is, in order for us to be full participants in society, we need to break down the barriers that are keeping us from that full integration. It means that we rely on doctrines like national origin, race discrimination, and anti-discrimination doctrines to the extent that those doctrines accommodate Latino identity. And sometimes they don't, right? So then we have to find protection in common law or in other statutes. And a very recent example of that is the publicity move that the governors of Florida and Texas made when they contracted commercial carriers to immigrants from their states to Democrat cities like Chicago, Los Angeles, New York, and Martha's Vineyard. To me, that's false imprisonment, right? Like all the elements of false imprisonment are there, and there's no need to apply equal protection like that. So we would take the cases as Malta because the victims are. So in short, Malta has focused its motivation on ensuring that Latinos have opportunity and access in several areas of law. In education, we've taken cases that challenge both segregation and unequal funding schemes that basically create segregated school districts. In employment, we challenge both differential treatment and systems, policies, practice that create a disparate impact on the consumer. In public services, we challenged public decisions that leave Latino communities underserved. And in voting rights, since the Voting Rights Act was changed in 1975 to include language minorities, we challenged voting systems and redistricting plans that dilute the vote for Latino communities. And in immigrants' rights, we challenged policies at the federal, state, and local level to create barriers to integration for immigrants. So the banking work that I'm going to talk about is really inside of our immigrants' rights agenda. So what are our tools? What goes into a civil rights agenda that prioritizes integration? For education, it's not just the segregation strategy in the 80s, but it claims for acting to the question. So regardless of immigration status, so we were involved in Fiverr versus Go, which stands for the proposition that children are allowed to go to school regardless of their immigration status, and they shouldn't be asked about their immigration status if they enroll in K-12 school. Because after all, if a goal of education is to inform, to create informed civic participants, then it should be open and accessible and responsible. In employment, we focus on barriers, not just to entry, but to advancement, and also barriers to dignity in the workplace or in an industry. And we use statutes like Title VII of the Civil Rights Act of 1964, which prohibits discrimination in the workplace based on race, sex, religion, color, national origin. And we also use Section 1981, which I'm going to talk about a little bit, to make claims of alienage discrimination. And in places where public entities are involved or where public services are involved, then we bring complaints to government agencies based on section 1983 claims. And until the Supreme Court got rid of the private right of action under Title VI of the Civil Rights Act, which required that public entities provide services in a non-discriminatory manner. And in the areas of credit services, banking services, membership, and credit unions, Malta brings on behalf of members using section 1981. And this is an important and under-theorized area of access, that is economic and financial access, that I think is necessary, that we as Malta think is necessary for full integration in our society. So we're all familiar with the types of lawsuits that arise from the failure or the refusal of banks to offer services to all the constituents in a geographic area. So some of these are covered in the Equal Credit Opportunity Act, which I'll talk about in a minute, which actually started because it was meant to prevent discrimination against women in access to credit. Other statutes include the Community Reinvestment Act, which ensures that banks commit to geographic areas where their branches are located. And these are all attempts to hold banks accountable that goes far back as the Glass-Steagall Act, which heavily regulated the activity of banks after the Great Depression. Slowly, banks have won their efforts to deregulate, and their activities have been much more controlled. And that makes private right of action that much more important, right, in an era of deregulation. Malta's approach is to represent those who are blatantly and openly denied access to the system. So, as I was looking at these cases through the lens of Malta litigators, we saw patterns in the types of people who are being denied access to credit services. And I looked to my colleague, Shaya Sarkar, who wrote a wonderful article called Capital Controls and Money Control, which I maybe in which his thesis was that capital was being used as a tool for immigration control. And the history of it is that banking regulation plus national security regulation created financial borders, very similar to the borders that we, the physical borders that we have, over things like identity verification. The result is that migrant access to capital is restricted, and we get an era of private enforcement of immigration through bank policies and procedures that keep immigrants outside of the credit system. That is, these economic barriers make it difficult for people to integrate, so people give up, right? Professor Sarkar is theorizing in an area where Malta is actually doing its work. But simply, why should we allow banks and financial institutions to discriminate when they provide their services? The simple answer from deregulated banks, from the deregulated industry, is because we can. And the bank's argument is that we should be free to offer our services to whomever we see fit, and to deny our services to whomever we deem unfit. And we deem non-citizens unfit for a variety of reasons, including that it's just too difficult to imagine what those financial services and financial instruments might be. So organizations like Malta sue because we want to ensure that discrimination is not what's clouding the imagination of these things. So what are our tools? Our biggest one is point to USC section 1981, at least at the federal level. Section 1981 is an 1866 law, a reconstruction law that basically says all persons within the jurisdiction of the United States shall have the same right in every state and territory to make and enforce contracts as is enjoyed by white citizens. So the terms white and citizens is really important here. The term that this means that everyone has the right to make and enforce contracts as whites, and everyone has the right to make and enforce contracts as is enjoyed by citizens. So there's a race as well as an alienage aspect to this statute. At the time of its passage in 1866 and its reinforcement in 1871, Congress was well aware of the rampant discrimination against foreign-born residents, also known as Chinese residents. So the equal protection principle that's embedded in the statute inserts into contractual relationships an assurance that foreign-born folks will be integrated into all aspects of the economic society, including contracts. This statute applies now to both public and private discrimination. So that's the statute used at the federal level. There, at least in California, there are state level statutes as well. California has a really strong one, the Civil Rights Act, which basically provides broad protection for all kinds of protected categories for the provision of services by businesses of every kind. So all persons, no matter what their sex, color, religion, ancestry, national origin, disability, medical condition, marital status, sexual orientation, citizenship, primary language, or immigration status are entitled to full services in all business establishments. So this is even more protected than the federal law in some respects. Immigration status, primary language, and citizenship status were added to the list of protected categories in 2015. And it applies to all business relationships, including credit services, with protected individuals. And violations of this resulted in a penalty of $4,000 violation. So at least in California, there is a private right of action that has actual penalties. That would make sense once you start to add up the number of people that are involved in the class action lawsuits. So it's these two sets of laws that separately and together form the basis of the claim that banks cannot discriminate against DACA or other classes of foreign-born residents when they offer loans, credit services, for membership to the public. So most recently, Mulder had heard from DACA recipients and others that banks and credit unions were not lending, right, or offering membership, and that they had policies that prohibited these services to anyone who's not a citizen or a lawful permanent resident. And these are official policies. We call them official policies because they show up on websites, right, on denial letters, in emails, and in texts, in those little chats when you chat to somebody on a website. The answer was we do not lend to them. So what are the types of cases that we're looking at? A wants to open a checking account and is denied because they have DACA status. B goes to a car dealership and is sent to one of its preferred bank lenders for a loan, and the bank denies the application because it's based on a work-only social security number. C applies for a home loan and the bank denies the application based on citizenship status. D applies for membership, just membership in the credit union, and again is denied because of their status. Or identity documents are denied. These are just documents that identify somebody as the individual who says that they are who they say they are, because the documents are work-only social security numbers, DACA-based employment authorization documents, time-limited employment authorization documents, or individual tax identification numbers. And that's not to say anything about matrículas or an all of these are people on the screen, these cases, all of these people, but all of these are people who have good credit, they have stable employment, they're long-term residents of the states that they live in, they intend to stay in the United States. So as far as the other underwriting criteria that exists, they pass all of those tests. In fact, all of these people went to other banks or other financial institutions and actually got credit membership. So these are some of the examples that we've encountered even in thought reviews and potential. It's our view that blanket policies that restrict lending to citizens and lawful permanent residents violate the laws that we talked about, Section 1981 and the California Municipal Consent. The purpose of the laws is to ensure that somebody is not treated differently because of their foreign-born status. And while these policies might make it easier for an underwriter to check the boxes on their guidelines, they are not valid. Okay, so how do banks justify their practices? I'm not sure that banks justify their practices. I'm just going to put this out there right now. These are the arguments that the bank's lawyers are making. Right? So it's not clear that any of us how these policies exist. Right there, if we look on, if you start going on banks' websites, somewhere you'll find we only lend to citizens or lawful permanent residents. Right? We offer credit to citizens or lawful permanent residents. We offer membership if you are a citizen. Right? So it's not clear. It's really not clear to us where those policies actually come. They've been around longer than the Patriot Act or the Bank Secrecy Act, or some of those acts where somebody might, some lawyer might say, well, these are the reasons for the conditions. One place where bank lawyers start is with the Equal Credit Opportunity Act, as I said earlier. The Equal Credit Opportunity Act was originally passed by Congress and implemented to protect women who were getting denied credit. And so it has now been expanded to other forms of protection, not just women. So now it's unlawful for any creditor to discriminate against an applicant on the basis of race, color, religion, national origin, sex, or marital status. And it's also, by the way, unlawful for a creditor to discriminate because somebody's income derives from public assistance, or because in retaliation for any of these particular requests. So bank lawyers start with the Equal Credit Opportunity Act because they say, well, it says that it's unlawful to discriminate on the basis of race, color, religion, national origin, sex, or marital status, or age, but it doesn't say anything about alienage. Right? So that's where they start. Their financial argument in this is that they need blanket policies because they're underwriting guidelines for it. And as I said, I think banks actually are thinking too much about why they have these policies and where they come from. And when they're pushed, banks don't really know why. They rely on regulation of the Equal Credit Opportunity Act, which is the regulation that implements the act. And there's a particular section of Regulation B that says a creditor may consider the applicant's immigration status as a permanent resident and any additional information that may be necessary to ascertain the creditor's rights and limits. So that's the fallback argument, right? Well, Regulation B says that we can consider immigration status or we're considering somebody's application because what if the person goes back home and we aren't going to be able to clean them or figure out what they must be right? So that's the sort of fallback argument that banks use. Our claims don't go as far as underwriting. Okay, ours is a very basic thing. Even if you argue that you can use it as part of underwriting criteria, you would be using it as one of several factors in determining whether somebody should be able to get loan. Some sort of financial service. It doesn't answer the question of why you wouldn't be able to hold a check, right? Or membership in the bank. Because when you create blanket policies that say we are only open to citizens and lawful permanent residents, then that's the only factor that you're using to determine whether somebody would be. And so at this point, right, in our litigation, we focus on that, right? Forget about, we haven't even gone into underwriting criteria on the disparate impact or the disparate effect that considering somebody's foreign status on an application. We're really just thinking about the first application. You're not even looking at the rule that people do. So all of our arguments have, and they've been successful. We've settled several of these cases, and in the settlement of these cases, banks understand, acknowledge the error of their ways, right? And open up banks. Because I think they recognize, right, that there are statutes that are being violated, and B, because other banks are doing it, and they're doing just fine, right? Opening up their credit services. One other fallback argument that I've seen in cases is that they really aren't discriminating based on foreign statuses, because after all, they give loans to all of them. And it's kind of like saying you don't discriminate if you have a policy based on pregnancy because so discrimination against a subgroup is still discrimination against. And so we kind of see that argument. And again, it's not a bank argument. It's not something that the banks thought of when they created the policy. This is the bank lawyers' arguments and as we get these cases into litigation. So our goal in the end, I think, is to open access to credit regardless of foreign status to everyone, just as it now opens it to the alternative to citizens. And I keep saying this, and I need help researching this, right? I'm sure that banks are offering credit services to foreign folks, whether they live in the United States or not. I'm so sure of it. But that's not something that comes up in these kinds of cases, right? There's a certain kind of foreign person, right? One who is not rich, that is really sense in these cases. And so the very first step for us is to open access to credit. And then maybe we can tackle the underwriting criteria and how they might affect applicants based on age, right? Some of these criteria might have to do with length of residency, or criteria that credit permanent social security members over individual tax ID numbers, that sort of thing. But really, we're not there. These cases are really about the first step of access. So while Malta has been successful in reaching agreements with individual banks to change their policies, the class action litigation mechanism is a pretty inefficient tool to change that. So how do we use policy avenues to make the change? And then what does that change look like, right? So I think the first step is for regulators to clarify that any reference to immigration status in the regulation relates to underwriting criteria and should be imposed in the same way requirements of citizenship. That is, questions related to anticipated length of employment, right, which is what we're only social security numbers do, should be considered for citizens as well as non-citizens, right? I should be asked, oh, you work at UC Davis? How long do you work at UC Davis, right? How stable is this income, right? And the same with other underwriting factors. And as I said, people have figured this out, right? In every one of the cases that Malta is brought, the client has gone somewhere else and found an honorable membership and credit. They've received their financial services. So what should the policy changes be based on? And I think this is where civil rights can step in. And the basis of Section 1981 and related state statutes is equal protection and fairness. And so we're always going to lead with protection, right? We're always going to be leading with fairness. But there are other arguments that I think make sense and actually do make sense to banks when they think about it, right? Is if you deny access to a whole class of people, you're living with them, right? The principles of capitalism are really strong in the financial services industry. And so, and as is I think the principle of economic inclusion, right? Banks, I think, understand that economic integration is a key integration in society. And it was along with the premise of Section 19, the premise, the basic premise of capitalism, the more people have, the more people will be able to offer services to, the more people. So these are my thoughts on one aspect of banking access, and I'm sure there's a lot more examples. When it was announced I was going to do this talk, I got an email from a friend who sent me a article from the New York Times and talked about discriminatory appraisals that banks commission, right? So that's one area that comes to mind. As is the devaluation and the disinvestment in minority communities when banks can take over smaller banks, but then don't reinvest in those communities. So all of these are examples of endemic problems in the financial system that would rather focus on what's comfortable, right? What a banking system is comfortable. And organizations like MALDAC really play an important role as private actors, keeping the systems accountable. I'm going to stop here because I want to get to questions and comments. And I welcome your questions and your comments, not just on the banking system or on credit or banking access as a civil right, but on other aspects of it. Thank you. Yes.
Thank you for your talk, Professor. I was curious, you mentioned that clients are able to find alternate financial services. Are those typically of the same quality, and are they potentially more vulnerable to the predatory lending services?
I think there was always going to be that question of predatory lending, right? So for me, that's kind of the next step. The first step is to get the access and then to figure out hold banks accountable so that the enforcement of contracts is the same as that is offered to white citizens. But I think you're absolutely right. In a lot of cases, it's large banks, right? So the first sets of these cases were against like, Wells Fargo and that sort of thing, right? So people are going to large banks and actually finding services. But you're absolutely right that they're at the intersection of foreign born status or immigration status and middle class status or poor status, right? You're going to find a lot of predatory lending, even yes.
So, over the course of your career in litigating civil rights cases, how does the state of play look today compared to when you started? Sort of. Well, I would just say that because we have this Supreme Court that appears very hostile to a lot of rights that we have sort of taken for granted, or at least people of my age group thought were sort of set in stone. How does that inform, I guess, the arguments that MALDEF makes in its litigation?
So it's the good thing about MALDEF, starting with equal protection, right? As its first line of attack in these cases. Because, and then it depends sort of on the state that we're going to be in, right? So MALDEF in California is really strong because California has some really protective laws that place equal protection as so I really do think it depends on the state or the region that we are in. I think it would be a lot harder than where right now, I mean, everything is going up on an emergency basis to the Fifth Circuit, like even on a motion to dismiss or something, everything goes on an emergency basis to the Fifth Circuit, and then all of a sudden you're in front of the Supreme Court with a week to write a response to a complaint or something. So I think we are careful to choose our battles at this point, right? And section 1981, alien use discrimination for section 1981 exists in many circuits and not all. So it is an issue that the Supreme Court could bring up and make a decision. So I think all of those things go into get considered, right? In California, we also very carefully consider whether it makes sense to even put in a section 1984 of the state law is that is protected. And then it depends on the sort of reach of the bank. What we're seeing now is that a lot of banks might be small banks, but they're big in the auto industry for some reason, right? Like they do a lot of business in auto loans, and they do it all over, right? So you're getting people from all over the country applying to some credit union, I don't know, or something that is doing this. So we have to think about all of those factors as we think about what this sort of makes sense. But it is a consideration, right? How quickly something can get up on the board and how we think when they do that in California. But I don't know that it's that different from when I started. When I started at Malden, it was it was right before Title VI of the Civil Rights Act of 1964 was being attacked. And that case went to the Supreme Court. And basically what was being attacked was the private and right of action. So individuals had a private right of action to sue public institutions, public decision makers about access to underserved communities, including language access. Right? And so we were using Title VI all over the place. And Title VI was like a really strong tool in our toolbox. And that case went up to the Supreme Court before, right? So all of a sudden we didn't have Title VI anymore, right? And we had to figure out how to retool. And I think that's where the principles of equal protection and fairness are really important. It means we either have to get the state to pass a law like the Civil Rights Act, right? Or figure out some other legal thing that will get us to the same place, that is how to provide services and understand. Yes.
Does Malden do any work with educational kind of initiatives for the communities that are being targeted by these types of practices to kind of inform individuals or communities about what their actual rights are, what banks can and cannot do? Or if not, is that something that you see as definitely not a solution, but as at least maybe a band-aid and kind of a step forward in some of these areas?
Yeah, it's definitely a step forward. And so one of the things, Malden considers itself a law firm, but it does have, actually I shouldn't say, the litigators consider themselves a law firm. There are other parts of Malden that deal with policy and deal with community education, right? So there is in fact something called the Parent Leadership Program, which is an organizing. It's an organizing group within the organization, and they do parent leadership workshops, and they do your rights sessions with parents in schools, and they're in different pockets of the country. Right? It's not a national program. They just in Denver and Tucson schools. And so they inform us, right? They inform our education. But in places where we don't have community education, we partner very closely with the community organizations due to the community. So I'm involved in litigation that was started by Workers Center, where they were coming in with all kinds of problems, and then the Workers Center reached out to us and said, how do we deal with this? Right, so we have a history of partnering very closely with organizations that do that kind of work, and that continue the work that we've done. And I think that's one area that I think I wish would be stronger, right? Especially when you think about voting rights, for example. We can look at a map and we can say, we as the litigators can look at a map and say, okay, our vote is the Latino vote is being diluted in this area, so we can actually create a Latino district where one is not being created. But if you create a Latino district and there's not organized among so I think we all think that it's really important to at the very least collaborate with and work closely with community organizations because otherwise the legal regions yes.
Is the legal footprint left behind by opening up these banking and savings accounts a problem for, like you mentioned, the type of immigrants who might be at risk of deportation compared to the ones who?
Yeah, that's one of the arguments. That's one of the arguments of the Mexicans, right? There's like, of course it makes sense. Like if you think about our logic, we're giving a loan to somebody, that person might be deported, and then what happens to our loan? What happens to our money? So our response to that is you've got to think about that with everybody else. That's why I was saying, what about the stable income, right? You better be asking me questions about how stable my income is, right? It's an underwriting criterion, not an analysis issue. Ironically, and I come at this from an immigration lawyer, right? Ironically, the one group of people that everybody, like all banks, right, are like, yes, we want to lend money to DEFRA, right, to DEFRA recipients. And I'm like, they're the ones that have all of the except for undocumented folks, right? Of all of the foreign born people who have some sort of status in the United States, they're the ones with the least amount of recognized status, right? But they're the ones that banks that are saying we are willing to give money to that group. And I think that in part that's because that's a very organized group of people. And there are ways, I think, for banks to feel like they have a level of support that maybe an individual person. But to me, if you're going to say, we don't want to lend to this individual because that individual is supported, doesn't make sense to turn around and say, but DACA folks, those are the ones we actually open up financial services. So the long and short of it is, I think that there are ways in our highly technologically advanced society that someone can find you if you leave the country, right? And you owe money. I might be wrong about that, right? But my sense is that banks have figured out how to do it. And for some reason, they want to restrict your regulations. Yes.
So I was just generally curious to what extent public pressure works in this area, and then the DACA point maybe think that even more. It's not just the increased visibility compared to other foreign groups, but it's the kind of purse strings aspect. You have people like the widespread
Yes.
type of support, distinctive type of support. Right?
Yes.
Recipients that gotten from quarters that other immigrants don't always get.
Yes.
And so if they're doing better with DACA recipients are doing better with banks, is there other kind of public pressure exchange of these that is successful aside from pressure through litigation?
So I think that it gets down to the policy aspects, right? Like what do we need to do to open the door, right, to everybody? And that's why I use that as an example, right? It's not about their immigration status. It's not about their intent to stay, right? Because if we actually create a rule that a bank will follow, right? In the remedial stage of this litigation, do we just say if the person has an intent to stay in the United States, that's good enough for the bank, right? And I think you're right that the response from lawyers who don't understand immigration, right, is that this group has enough support that we think that their intent to stay will actually come to fruition, right? And I don't know. So the bottom line is that it is unorganized. It's mostly an organization. From an immigration law perspective, there's this whole other category of people, dual intent immigrants, right? The individual comes to the United States on a temporary visa, but because of their work or because most is because of their work, they're eligible to apply for immigrant visa. So they have access to citizenship. That's an example of people that banks are like, I don't know, that gets us too much into the ABCs of the temporary immigrant status categories, and we don't know who we want. So I think you're right, there is an instinct that it's because of organizing that makes a group of people acceptable, I guess, to the financial institutions. But it doesn't make any sense to me as a question.
There are certain kinds of research that would be particularly helpful to MOLDEF as it's litigating these cases at the intersection of immigration and banking, because there's so little other than Professor Sarkar's work. There's almost like nothing out there in this intersection, like almost nothing. It's what kinds of, students are doing sort of independent studies or people are doing other kinds of academic research. Like what would be helpful?
I think research around the purpose of laws that banks are now using. So the first step is the Equal Credit Opportunity Act, right? I didn't even get into the Patriot Act or the Banks and Business Act or all these other acts that say these are identification. There are reasons that have to do with identification, right? So that require us to have this rule, right? So research around the purpose of those laws, the sort of background for why we didn't have them in the first place, that sort of thing. I think it's really important. The same with the Equal Credit Opportunity. And then research on statutory interpretation. What does this limited statute that limits underwriting criteria apply to students? So it's that kind of research that I think hasn't been very much. And I think that Professor Sarkar's article was a sort of first step in that direction, but you're absolutely right. When we look around, we're not doing it. And then there's social science research, right? It's like, I just know these banks are giving, we just say,
but they separate their commercial banking and private banking, and I assume with respect to private banking, they are providing private banking services.
But that was the not regulation, right? Is that we can go back and forth, right?
Yeah.
So
they
that's
separated quite a bit.
Let's do it. Let's go. Right, and so there's not that kind of I don't know what it is, social science research, right? Hasn't been done. The kind of research that allows us to very easily rebut, right, an argument that's based on fact. Yes. Oh no, John is a real banking expert, so now.
No, I think couple. One is like it's weird if they're like, oh, I'm not going to lend you if you're subject to deportation because you might get deported. Collectively, if they're not also saying you have to hold property in defense, you have to hold property where it's subject to whatever seizure. It's no easier to get property in other countries, but it's harder than to get. Others may have more knowledge of this than to get personal jurisdiction the first time. So that's just weird. The second thing is, can you go back to that regulation?
The regulation.
Yeah, that.
Yes.
Is that, so is the idea that like the immigration status is necessary to ascertain rights and remedies? Do you think that's what it's trying to say? Or do they say that's what it's trying to?
Yeah, well, it's what banks sense. It makes no sense whatsoever. And if anybody wants to do research on how we got regulation B and this particular
What makes me
section,
wonder.
Go ahead.
It makes me wonder if there's like if this. It makes me wonder if there's a statute that says they can consider creditworthiness and then they kind of try to shoehorn immigration status in there by saying, oh, it's relevant to rights and remedies, which is not.
No. And actually, we had an issue, and I did have the Equal Credit Opportunity Act statute up, right? And it didn't get into this version. But there's nothing like that in the statute, right? So so this regulation B is overreaching.
Yeah.
I don't know why. I don't know why.
This is you guys a chance to take advantage of the hostility of the administrative state.
Yeah.
Just get the designated to meet your request.
Well, that's good. I love it. That's a great argument. But yeah, that's, I think, Charlotte's course, point. This is where we need research, right? We need some like legislative, straight up legislative history, like how did this get here and who, what congressman was in that room that day, or what, who forced this into the regulation. But even though it's there, right, I also think it was in part lawyers for the banks saying we need some sort of protection. Then it has a rule that's wrong and people but even then, right, you can feel the pushback in the regulation, right? That doesn't mean that you close your doors to people who are born in one space, right? And so, one that we keep waiting on that because this is about one of many factors rather than a rule. And that's my question, like, there are citizens who, buy an RV and then move to Mexico, and then they have a loan in the United States and their RV is in Mexico, right? Are they getting asked the same questions that people who are born and against, right? So when we get to that litigation, that's when I think this regulation comes in, right? But otherwise it means. Thank you all for your time.